everybody, and welcome to the Data Protection Made Easy podcast. This is season 2, episode 9, where we are talking all about restricted transfers under the GDPR. I am joined today by Mark. Mark, how are we doing?
Very well, mate. Very well. I've just sort of calmed down there after my long BCR rambling.
Yeah, no, that's right. It was a little bit more of an informative session today, instead of the usual kind of waffle that we provide. Fortunately, we are joined by an international transfer expert, and I'm not talking about myself. I'm talking about Mark, who has spent countless years and got plenty of experience in working with international transfers, namely BCRs that he spoke about at length and gave some great value to the listeners in the chat. Mark, how did you find the session?
I tried my best, mate. No, joking. I thought we covered a lot of ground there, because we covered obviously I gave a little bit of insight there, my background in BCRs and so on. Because obviously it is one of those kind of underexplored areas, isn't it? People don't know too much about it, so it was nice to kind of bring that to the fore and obviously add some detail around it for people that are probably obviously not too knowledgeable on it. But we also sort of tied that to like a recent news updates and so on. We talked about the ICO's new guidance. So, I think we gave like a really good overview there of obviously what those changes are going to mean in practice.
Yeah, absolutely. As you rightly said, we spent a little bit of time looking at some other news pieces around the world, focusing a little bit on some of the issues with Monzo that we've seen recently, if any of you guys have been on LinkedIn and seen any of the information around that. But we won't give too much away. We'll let you jump right into the session because it's a good one, and we'll see you in the next.
Enjoy.
Let's jump right into the session. So we're talking about international transfers today, but I thought before we touch on sort of the main topic at hand, we'll have a little look about what's gone on in the news, because I've got two pieces of news. One of them feels particularly relevant, and the other one not so much, but I think it's a really interesting case. The first one being probably what you guys have maybe already seen on LinkedIn, especially if you follow DPO Daily, Tim Turner. I'm sure pretty much everybody in here will know who Tim Turner is, or at least DPO Daily, which is run by Tim Turner, around the case of Monzo and their current scrutiny over their misuse of personal data. Now, the digital bank Monzo, I'm sure you guys probably will have heard of it. It's obviously relatively up and coming in the space of sort of digital banking, and is quite commonly used now, I think, especially among sort of the younger generations, as like their main sort of banking now. So they've currently been facing criticism for using their customer data to generate year-in Monzo spending reviews that some users have labelled as shaming and humiliating. So the service predominantly was designed to provide a summary of sort of the spending over the year, kind of similar to what you get with Spotify, with your Spotify Wrapped, but has instead kind of divided opinions on people's perspective of, where the line is. And it feels almost like a commentary to potentially tease a customer and their financial habits. It seems to be in a very particular case where an individual has come forward and raised a complaint to the financial ombudsman after receiving a review that mocked her frequent use of food delivery apps, so things like Just Eat and Uber Eats and stuff like that. So the automated summaries told her that she had fast fooded more than most, referenced a beige diet, and suggested that she should just stop spending. So this individual has elements of chronic fatigue and has a history of eating disorders, and has argued that commentary like that can be relatively damaging for people like that, and for people that are obviously experiencing things like that, and can also have an impact on the way that she then acts in the future, leading to obviously further complications. Now, this was really interesting, and I thought a really good debating sort of topic, because I appreciate what Mondo are trying to do there, but I wonder if they've really thought about the actual implications of these kind of statements that they're making. Obviously, because they're very general, but I don't know about you, Matt, but I don't know if they've actually really considered the broader implications of commenting on people's financial spending, because I think that can definitely be a very sensitive topic.
Yeah, I mean, I wouldn't have thought that they would have covered their bases from a DP perspective at all on this, because just thinking off the top of my head, what would be the lawful basis?
I mean, it's a great point. We're obviously looking at their spending, and I think even in a harmless way, I don't think we're fully aware of the actual implication of that to the individuals on the board. We're dealing with so many different individuals who will use these sort of banking apps, and I think we've noticed that, you know, as of now, I think the way that the online sort of world works is people will really attack certain trends that seem to be just, I guess, in the space at the time, things that are popular, things that are common, and it seems like that is obviously an attempt to take what Spotify have done really
Yeah.
successfully. It seems like everybody does that now. I think I've seen that like Asda does it. I know that sounds silly, but Asda will tell you what you've spent at Asda over the course of the year. And it's just an attempt to jump on things that are obviously clearly in the space at the moment. But when it comes to things like financial information, even if it doesn't particularly link to any kind of, in this case, an eating disorder, it doesn't mean that people still feel comfortable having their,
Of course, yeah.
financial issues sort of waved at them, especially if, they struggle financially or that maybe they have a difficult spending habits and it's something that they're trying to get better at. I don't know if it's, I think you're right. I think data protection just hasn't been considered at all. But even just from a moral perspective, I don't,
Yeah,
I don't
yeah,
really
on
think their
that.
feelings
Yeah.
have been considered very much.
Clearly not. I mean, it was pretty kind of harsh, really, wasn't it? The
Mm,
comments. I'm not surprised that this woman's complained. Obviously, I've seen it. She's complained to the Financial Ombudsman Service rather than to the ICO. But it'll be interesting to know if there is any ICO involvement in this at all.
Do you think they will get involved? Do you think they will opt to get involved potentially?
I mean, I don't know. I mean, I was looking at the DPO Daily Post. I mean, he obviously doesn't think so. I mean, I would suspect that. I would suspect if a complaint was made, then yeah, I think they would get in touch with Monzo and be asking them questions.
Mm.
Whether or not they would respond, just on the basis of this news report and say, right, we're going to pick this up and investigate it. I don't know. Maybe from their perspective, there might be more pressing matters. I'm not
No, for
sure.
sure. I
Yeah,
mean, I think they've got a lot going on at the moment, haven't they? Clearly, with obviously still the stuff around Grok, and it seems like there's a few fines sort of floating around the space at the moment as well, isn't there?
exactly. Yeah, because I wasn't saying that to kind of, dismiss the distress that clearly could have been caused here, but I suppose yeah, when it's up against issues like the Grok issue,
Sure.
this is
Yeah,
obviously
yeah.
going to come behind that, isn't it?
Well, they're taking that sort of new sort of high risk based approach now, aren't they? To their
Yeah,
I know it's specifically to complaints. I mean, we don't know so far as if the ICO maybe has been notified to some degree. Maybe someone's taken it into their own hands and gone to the ICO as well. We also
you
don't know
never
that.
know. Yeah, I mean, this is obviously just one particular customer, isn't it? But of course, there could have been others that had a similarly bad experience. But
Mm.
yeah, it's just really hard to see how Monzo would justify this from a
Yeah,
DP
no, for
perspective at
sure.
all, isn't
I
it?
mean, I use Monzo, but I sort of use it for sort of more like one-off sort of expenditure, like kind of occasionally. I'll put it in like a random spending pot, and I'll just use it like when I'm like shopping and stuff. So it's more for like income that I'll use for me as opposed to like on bills and just like shopping for food and stuff. So
Yeah, didn't it have a lot of like cashback offers?
yeah, yeah. I just don't know how
Yeah.
I'd feel about knowing that they're assessing my spending to effectively make like comments on it. Especially, you never know the impact of that potentially if someone is potentially dealing with gambling issues and stuff like that. The implications of that could be huge if someone's sort of waving those in their face. If you can be a
Yeah,
recovering
no,
addict
I
from
think
some
I think
elements.
it's a
So,
great point, and it's great. But I think it feeds back into this notion of with movements like open banking and so on. The banks and the financial institutions, they are gravitating towards, can we get more of people's data and can we use it in more kind of creative ways? And clearly, Monzo would probably argue here that we're trying to improve the banking experience for our customers. We're trying to give them more insights into the spending and so on.
mm.
And of course, if that was consensual, it
Yeah,
could have
no,
been, then
exactly.
fair enough.
I can't
Obviously,
imagine it's something that's covered on that initial touch base when they're signing up.
I
Really
wouldn't have
doubt it.
thought so, no. But it would be interesting, yeah, to look deeper into that and see exactly what their T's and C's do say. Yeah,
Yeah, no, I mean, I'd be keen to understand, and I think potentially we're going to see a lot more of cases like this. Unfortunately, I think we're currently in a state of time with the use of apps and social media where it is a real clamber for things to remain relevant. It seems like individuals' retention to just certain apps and uses of stuff kind of changed because there's so much coming out. There's so many new things. People have really got to fight hard just to kind of like get your attention.
Yeah, yeah,
Um,
I think it's a great point. That's probably what they've tried to do here,
yeah.
although it does seem it may have backfired.
Yeah, no, for sure, and we could
Yeah.
definitely see more of it. I think loads more people may piggyback on the success of Spotify Wrapped, but I guess Spotify is fairly harmless in the results that it's sharing. I mean, I don't know if Spotify Wrapped is something the financial sector really needs.
Yeah, I mean, yeah, again, they've tried to be creative, haven't they? And on the one hand, yeah, if people are down for that, then that's great. But
Mm,
as you've pointed out, our spending does tie into a lot of very sensitive
absolutely.
information about us.
And you can't tell from it would be very difficult for Monzo to understand from the outset if oh, we shouldn't say this just in case someone has X or Y. Even if it demonstrates really good spending habits, we still don't understand really the implications of how that could affect an individual. Depending on a period of time in their life, maybe depending on the things that are going on internally. So, I mean, it's got to think about the benefit, and is the benefit worth the way we're using the data and the potential impact? No, I definitely wouldn't say so. And I'd be keen to see, as you say, what they've actually done internally. Probably nothing from my understanding, if I had to guess. But no, I think James, you're absolutely right. It's a much more of a loaded statement that Monzo would be making,
Yeah,
and as opposed to as
absolutely.
you're
Yeah,
right, just saying you listen to a
yeah.
lot of Rick Astley, as much as some people might be like, well, Rick Astley's not my kind of thing. I think the implications of that is fairly minor. So hopefully it's something we won't see more of. But I would hazard a guess is that that it could be things that some apps may have already been swept under the rug in that regard. Because as I say, I think Asda did it. Again, I can't imagine that's going to be as harmful as this Monzo case, but there
I
may be
think
other
I think it's a
people
good point though,
utilising it.
because when you say would the ICO get involved, I mean, I suppose if the ICO doesn't get involved at all, then that's almost giving this kind of thing a free pass, isn't it? And maybe other
Yeah, no, for
companies are
sure.
going to be again more risk averse as well in doing similar things. When in actual fact we can see from a DB perspective how is that being addressed, and
Mm.
also it's causing people distress.
No,
So
absolutely. Well, I think we've lingered on that point for a while now, and I think it was a really useful conversation. All right. Oh, interesting, Carly. Sainsbury's did it, and someone was the top Mars bar buyer in his eye. You know what? I can get behind that. I can get behind that. I really can. I do like a Mars bar. I'm sure you can tell.
got to be
But
with a monster on it, surely.
yeah, well, it'd probably be Monster with me. I imagine if our local Tesco's did it, I'd be ranking in the top 0.1%. So Monster, if you're listening, get in touch. Great brand promotion for you guys if you didn't notice. But no, it is an interesting space that we're in at the moment. Especially marketing has really changed, hasn't it? And I apologize that we're kind of lingering on this point, but I do think it's really interesting because I think the way that the aggressive way maybe that social media has become from companies, and in the way that they kind of like market things to people, the way they discuss products and sort of try and gain the attention of users is very different. And I think it's about really understanding the needs of, because what people want is they want something that people can obviously put on their social media and share, and like, oh, look how great this is. My Spotify, you know how excited everybody gets about Spotify Wrapped. Don't know if Sainsbury's Wrapped is going to quite do the same thing, but I think that's the intent, isn't it? It's the intent that something catches on, but you got to look at the relevance of the data that you're holding. A listening history of maybe the fact that you like to listen to the Moana soundtrack in your spare time, as opposed to your spending habits, are very very different. And I think if companies are going to take that approach, then you're really going to have to think about it broad term. Maybe look at some kind of DPIA, or at least understand the scope of the data you're collecting and the potential risks of that as well.
I think so. Absolutely. Yeah, no, it's a very important conversation to have, and we'll definitely be following this story and other similar stories that I'm sure will emerge. But
Absolutely.
of course, we are sort of convening here today to focus on international transfers, aren't we? Which is an area that I should know a thing or two about, having obviously worked at the ICO on their BCRs and international transfers. So I wanted to kick us off today, Caine, talking about the updated ICO guidance on
Sure.
international transfers, which has recently come out. And the ICO actually did a webinar on Tuesday to sort of talk through the updates, which I thought was really useful. And I mean, we can see the guidance that it is designed to kind of make things more simple, I suppose. And I believe further to that, ties into the ICO's kind of commitment to support innovation and economic growth. And I think to that extent, the ICO also mentioned in the webinar that they are going to be further developing other guidance in the international transfers area, linked to TRAs, the IDTA and cloud services and so on. But they've also got like an interactive tool and some additional kind of case studies on restricted transfers to come out. But I mean, in the webinar, I think maybe the headline would be that they sort of emphasise that in terms of the doer updates, if you were compliant before, then you're still compliant now, essentially. Obviously, there's a few differences that we want to take note of. So the requirement for a TRA, basically that's now going to be called a data protection test. Although, it doesn't roll off the tongue
Yeah,
as
it's
easily as TRA.
a bit of strange. I always hate when these are the things that are being discussed and changed. I don't know if you remember with like the DPDI, and they were trying to change the name of everything, weren't they? And obviously I know we've moved to the Information Commissioner now and stuff like that. Again, doesn't roll off the tongue quite the same, but I didn't think there was anything wrong with TRA. I quite liked the way it linked with like everything else, basically like being like an A at the end in some kind of way. DPIA, IDCA, DPA, TRA. I liked it, but I
If
mean,
it's not broke, don't fix
if
it.
that's what they want to call
Yeah.
it, maybe it's easier to understand. Maybe the phrase transfer risk assessment is slightly confusing. I mean, I guess from my perspective, when talking to customers, I really came to the conclusion of a lot of people wasn't actually aware of the existence or need for a TRA at all. And if they were, it was a very base level understanding of what a TRA was. And that seemed to be something that I was kind of coming into quite a lot, especially kind of quite early on into my career in data protection. But I know you attended the webinar, Mark. How did you find it? Obviously, I didn't attend because it happened to be at 5:30 on a Friday. But it seemed like you said it was quite valuable, wasn't it? What do you feel like people would have gained from that if they didn't happen to be there?
Oh, well, yeah. I mean, that webinar was Tuesday. The Friday thing was something else.
Something else. International transfers
Yeah.
still though, right?
It was, yeah, still in top
Ah,
transfer. I will probably mention that later on.
oh,
But
okay. I'll hold you to that.
fortunately, this one, yeah, this one wasn't held then, so I think obviously a lot more people attended. I mean, I thought the session I thought it was useful in a sense of obviously hearing, sort of spokesperson from the ICO talking about these changes. And I mean, what they've done, which I thought was good, was the sort of put out the questions in advance. So
Oh, okay.
a lot of the session was focused on answering people's questions. But what I noticed was, though, in the chat, there's probably a lot more questions being asked, in response to what was
Yeah.
being said. So I think there was some confusion to come away from it. But just to kind of expand on what I was saying before, so obviously we have now this data protection test, just change in terminology basically. But of course, we do need to note that under the DUA, that is now for a formal legal requirement defined in the statute. It's not just something that's best practice or, taken from case law as it was previously the case. So adequacy assessments, again, there's another terminology change there. They're now going to be called transfers approved by regulations, again, which I think doesn't roll off the tongue as well. I'm going to carry on calling it adequacy personally.
Yeah, I think I probably will.
And I think those adequacy decisions now are going to be subject to ongoing monitoring rather than having this kind of 4-year periodic review. And we also have like the Secretary of State now has the powers to introduce new Article 46 safeguards, which I think is something we may touch on later on if we have time. But I think probably the big takeaway, I think, in terms of how is this going to change things in practice? And again, this is another kind of change to terminology, which I think on the surface you might think there's not much in it. But essentially, this update, which is going to apply both to adequacy regulations and to TRA, is changing the requirement for the overseas jurisdiction's DP standard. It's changing it from that jurisdiction standard having to be sufficiently similar to now having to be not materially lower. So again, I think you probably look at that and say, well, what's the difference? I mean, it is a very subtle change, but I think what it's trying to do, it's kind of trying to say that look, the standard of the overseas territory, it doesn't have to be exactly the same. It just has to be not noticeably kind of worse off. And I think probably the hope with that is that it is going to pave the way to more adequacy decisions. Now, just to mention the thing that I attended last Friday, which was with Eduardo Easterin from Hogan Lovells. It's obviously a big, obviously figure in DP and also within international transfers as well. And he was just pointing out that, of course, the EU has kind of gone ahead of the UK in terms of adequacy, in that obviously it's made Brazil
Yeah,
and adequate
sure.
territory. So maybe this little sort of change in the wording is designed to maybe help the UK actually,
Sort of catch up.
catch up, probably even leapfrog. If we can start
Mm.
saying, well, if what we're bothered about is it's not that other territories have to kind of copy the UK standard, the UK framework. They just have to be, as I say, not notably worse off.
Yeah,
So
it's an interesting phrase in a word, isn't it? And obviously we can see that the EU are making quite big strides to do as much as they can to get as many countries sort of adequacy decisions as they can. I mean, I know as sort of discussions are currently ongoing with Canada and looking to begin a digital trade agreement, again to sort of move it a little bit easier to make organisations transfer data and potentially look at adequacy. Potentially, we'll get more of a lines of partial adequacy with things like the EU-US framework. That again will probably likely piggyback on depending on the sort of ruling of that. But I think to me, the wording definitely feels intentional. I think initially a lot of people just thought it was, change a wording for the sake of it, which maybe it is to a degree, but there definitely is a big shift from not material lower than to essentially equivalent, although a very minor tweak. I think there is going to be a lot more of a focus in allowing free flowing data
I
between the
think
rest
so.
of the
Yeah,
globe. I
yeah.
think I think so anyway from my perspective.
Well, what it kind of made me think of was when I've done TRAs, I think it can get to a point where where you are almost kind of splitting hairs on things,
Mm,
because I think we can sort of see now that of course more and more countries around the world are adopting uh, we're adopting DP frameworks. And of course, these frameworks, for the most part, are largely sort of derived from the GDPR standards anyway. So, and it's not that these other countries obviously mirror the GDPR standards exactly. Of course, there are differences and discrepancies there. But I've found sometimes when you're actually conducting a TRA, it, it's it, you can get quite bogged down, can't you?
mm.
In that you may have certain provisions which are broadly similar. There may just be different carve outs or exemptions there. And it almost takes you down that thing of, well, it's not essentially the same. Okay, but is it, not materially lower? So I think it does give you more freedom to kind of avoid getting bogged down in some of the minutiae
Mm.
and sort of look overall, is this actually a worse off standard? Okay, it has some differences, but do those differences make it worse off? Is the key.
Yeah, and I think that's the key. I mean, maybe we're looking at try to look at laws as maybe looking at we want carbon copies for the GDPR. I mean, some of the frameworks you see do feel very similar, don't they? I
Absolutely,
mean,
yeah.
when I was looking at the PDPL in Dubai a while ago, I was noticing that there's some quite large similarities there, and a lot of other similar frameworks that feel like it's leaning off elements that are definitely not as strict. Definitely doesn't feel as strict, but I could definitely see or understand at least maybe from the perspective of economics where they'd want to allow more adequacy for countries like Dubai, which are obviously becoming a bit of a hotspot at the moment for new businesses and things like influencers and new brands and whatnot. So, to me, maybe it feels like a little bit of more economically driven than potentially having much of a care of the actual adequacy of a country. But it
Yeah.
probably leaves a lot in the hands of an organization to really sort of safeguard that data. I mean, I know we kind of look at international transfers with adequacy as something that is kind of business as usual. But I still think there has to be some kind of element of care that goes into understanding the flow and the potential risks of that. Because I don't think it's something that's considered awfully much when it goes to a country with adequacy. Really.
I think it's a great point you've touched on there, just in terms of it being very economically driven, because I think that is obviously at the heart of DUA
Mm,
as well.
yeah, sure.
They obviously want it to help businesses rather than hinder. Um, and I think in this regard, another thing that I'd kind of say about the ICO's guidance and the webinar and so on is that I think in some ways it does represent a deviation with the doer changes, obviously from the EU position. So there are differences there now, but I think you would still point to them being very similar. So just to touch on some of the ways I was just reading up earlier on, obviously some of the ways in which they are still similar. For example, both UK and the EU will consider, remote access can be a restricted transfer.
Sure.
Although, interestingly enough, this actually came up in my work this week where we have a situation of a colleague taking the work laptop on holiday overseas.
Yeah, rules are
Um,
slightly different there, aren't they?
exactly. That of course isn't remote access per se as a restricted transfer because the data's staying within the
Stays
same
within the scope of the
entity.
business, doesn't it?
Yeah,
And I
exactly.
think that's the key. And maybe sometimes I feel like what people sort of trip over a little bit, Mark. I don't know if you see it from your perspective in terms of understanding what makes a restricted transfer. I guess the rules that can feel a little bit nuanced, can't they? And we know that in terms of what the law says going there, it goes to a third organisation as in a separate party, and is either accessed or well as in shared to. But I know that then also covers accessed as well to actually being held there as well. But the new ICO guidance has kind of updated all that and added some sort of FAQs in. Now, I don't know if that's from the perspective of sort of an SEO perspective, but I think they're quite useful. I think it's really quite a good tool. And I know I'm very quick to sort of go for the ICO where I can, but I was pretty pleased with the international transfer guidance that had recently been published. I think it's really quite helpful. I don't know if anybody else maybe in the chat that will use it a little bit more has had any essence to digest it and have any thoughts maybe on the contrary or maybe to agree with me. But I'm quite pleased with some of the stuff that they've produced on the doer stuff so far and the updates to guidance that we're seeing is hopefully going to be quite a positive thing.
Yeah, I mean, I think it's a tricky area, isn't it? International transfers. It is a complex area, and I will say that the webinar, I think I did sort of touch on this before. The webinar was marked with a lot of questions in the chat, sort of querying, the ICO's position
Mm,
and so on and so forth. I think one area that I noticed did cause a lot of confusion was around the restricted transfers, obviously with them being outside of the UK.
mm,
Now, of course, the ICO's position is that that is where the receiving organisation is legally established. It's not the actual geographical location of the data. So this is a confusing thing to understand, actually. So, if we had, let's say a business has operations in China, but it happens to only be registered in the UK. Sending data to that business, technically speaking, there is no restricted transfer there. Or you could have another situation where, let's say, a UK company is using a Netherlands-based company for a service, and the Netherlands company is delivering that service to its UK subsidiary. So we could have a situation there where data is not even leaving the UK,
mm.
and as the contract in this sort of imaginary scenario is with the Netherlands company, then it is a restricted transfer. So
Yeah,
it's confusing.
it's worth understanding the flows, isn't it? I mean, I think we always see it from the perspective of like, oh, sometimes you see it both ways. Sometimes it's they're based in the US, but their data centers are in the UK. So it's either there must be a transfer then because the main offices are in the US, or there isn't a transfer because of the contrary, and we're operating off the data centers in the UK, and that can be a difficult game, and it really depends, doesn't it? And it can depend on the nature of the business and the nature of those main offices in those instances of how far they're actively getting involved in if they can potentially access those data from the UK data centers. If I can, there probably is a transfer there. Whether maybe it's something routine or not, we don't know. But if it is something that is likely to happen or could happen, then there probably is that transfer there because they're still accessing that data. Whether it sits in the UK or not is probably for the sake of this irrelevant if it's a third party. But it's about really understanding the flow of the data with international transfers, and I think that's something that is maybe the biggest task. And I know it's something that we deal with a lot over at Data Protection People because it's something that, from a resource and knowledge perspective, that people can struggle on. It's a really hard task when you spend so much time, you know, in the UK GDPR, and then you have to filter over to the Chapter 5, do your TRA, and that's probably where the difficulty comes into me. Obviously, I mean, a lot of the appropriate safeguards I think are a little bit straight shooting. Some of them just aren't really utilised by a lot of organisations, and we'll probably talk a little bit about that in a quick second. But I think the TRA is where the difficulty comes in for a lot of organisations. How do you balance the right of two separate laws that do the same thing, and how much do you think, from your perspective, other legislation and even potentially the political climate of that country actually affects how we determine what is not materially lower than? Because to me, I think as much as they may have stringent data protection law, there may also be other law that as have subsequent real life factors, not even just law, just potentially what may be going on within that country or that destination at the given time as well. I don't know what your thoughts are on that, Mark.
No, I think it's a great point because this kind of ties into another one of the newer changes, which is there's now, I think it's the Secretary of State has this power to basically blacklist transfers to certain countries. So as you say, there can be situations where conceivably, it just can't be appropriate to send data to certain nations. And I think, of course, it's also important to remember, and this was something that was sort of requested in a way on LinkedIn, was that, of course, there are situations where um, maybe you're not able to put a safeguard in place, or maybe that safeguard is not going to be effective, but then you still, for whatever reason, need to make the transfer.
Mm,
And this is, of course, where we see the kind of third part of the hierarchy, so to speak, from adequacy, obviously, onto safeguards, onto uh, exemptions or derogations is referred to
mhm.
under Article 49. So, I mean, my sort of understanding experience of these is that these are really for sort of one-off transfers, really. And of course, they have to be necessary and proportionate, to make the transfer in that scenario. As you touched on there, Kane, for routine and regular transfers, this is where your data mapping is coming in, and this is where you need to sit down, do your TRA, and make sure you've got the right safeguards in place, essentially. Um, and of course, there can be scenarios as well in terms of derogations where you might use them alongside a safeguard. Perhaps you've done your TRA, you've identified a safeguard, but maybe that safeguard is only going to protect some of the data and not all of it. But maybe you still want to make the transfer, so then maybe an exemption comes in for that other data.
It's really interesting, and it's normally something that I operate on a lot and discuss a lot. The derogation. So whoever on LinkedIn reached out and asked us to talk about that, I really appreciate it. So thank you because we took a little bit of time to look at it. Because I only say I've probably ever once or twice ever looked at it in current cases that have popped up, and it's very interesting how it works in terms of the flow of that sort of one-off transfer and the fact that it can also kind of relate to data that we can't fully protect, that we still kind of half have a appropriate safeguard for us. It's a really interesting point. And obviously the doer have kind of expanded on it, as you mentioned, by the compelling legitimate interest, which I think definitely opens up some doors in terms of wiggle room for justification. So really, really sort of keen to understand a little bit more about that as I go with international transfers, to be honest with you. Now, on my end, I think what I would like to do is I think I'm gonna spend the last maybe couple minutes or so, last 10 minutes or so of this podcast being a little bit quiet actually for a change. Because Mark, I know with your experience, as you mentioned with the ICO, you've spent a lot of time in particular over on the end of BCRs. I know, Charlotte, I know it is a shock. It's not one of my best traits being quiet, to be honest with you. But I'll try my best. I will. But yeah, you had a main background in BCRs, didn't you, Mark? And I know you were involved in reviewing and approval of certain processes in relation to the BCRs. So I would be really keen to get some of your thoughts and share some of your knowledge and wisdom on BCRs, because I know it's something that people don't really refer to very often in terms of appropriate safeguards. From my experience, over on managing the sport desk and as a consultant, people tend to obviously go straight over to the standard contractual clauses or maybe some other measures. So some of your valuable insight, I think, will be great for some of the listeners.
Sure. Yeah. Well, yeah, it does feel appropriate, obviously, with my background, particularly in BCRs, that, we should spend a little bit of time talking about them. I think perhaps moving forward, we might find time to maybe dedicate more of a session to them and talk about them more. But I'd say, you're right there, Kate. I think they are like quite underexplored in the DP space. I think there's probably not that many companies or sort of DP practitioners actually have a lot of experience with them. I think you could say that probably is largely to do with the fact that they are confined to multinational corporations, essentially, and they are a mechanism that are used by these multinationals for their internal transfers within their corporate group. So for when they want to send data to their overseas entities, and if you were to cast your eye over the sort of list of approved UK BCR holders, you'll notice a lot of household names there. For example, like Mastercard, American Express, BT, JP Morgan, to name a few. And of course, we've got BCRs for controllers and BCRs for processors, and the requirements are slightly different in some respect, as they are with the obligations of a controller and a processor more generally. So, I mean, what BCRs essentially do, if I had to sort of explain them in a nutshell, is that they basically bind the corporate group's overseas entities to the UK GDPR standards. So, in that sense, they are seen as creating basically a gold standard of DP compliance that runs across an entire company. It's like that company kind of has GDPR standards running through its veins, so to speak. And I think in terms of, I suppose that's an explanation of what a BCR is. But in terms of why would a company want the BCR? What is beneficial about them? Well, I think they can be seen as more cost effective and easier to manage for these big corporate groups than other mechanisms like FCCs, because of course a multinational is going to need to have various different SCCs in place to cover just its internal transfer. So if it can get a BCR in place, obviously it kind of takes care of all that side of it in terms of data that's sent around internally. And obviously BCRs are not compulsory. This is an option that a company decides on. And it's really kind of raising the standard globally, essentially bringing it up to GDPR standard, as I say. And in a way, it's also useful to have this framework in place, because then when these multinationals do, let's say, buy up or, sort of initiate new subsidiaries and so on overseas, those subsidiaries can then just sign up to this existing framework, rather than obviously, another process of putting more separate contracts and agreements in place and so on. So, and also because the BCI is obviously approved by the ICO, that can do a lot for a company's reputation, because it's kind of demonstrating that that company has presented its framework to the regulator, and the regulator has given it the thumbs up, essentially. So it's kind of showing that that company, does meet a high standard of DP, not just in the UK or in the EU. Obviously, got EU BCRs as well. Obviously, EU is kind of where it comes from, but kind of globally. But one thing I will say about BCRs is that the requirements are extensive, and I suppose this kind of feeds back into the you know what it does for a company's reputation, because it has to meet so many requirements. Again, it is sort of evidencing that high bar. A company has to satisfy the ICO of the legal enforceability of the BCRs. All of the data flows involved have to be made clear. It has to show adherence to all of the sort of data processing principles and data subject rights, and and as well as various other areas, the compliance oversight framework they have in place, how they're going to deal with complaints, auditing, training. And there's obviously other areas beyond that as well. I won't spell out the whole thing. And there's also some tricky requirements as well in terms of like third-party beneficiary rights and liability arrangements as well. So it's not probably the most straightforward or easiest thing to obtain necessarily. But I think there are a lot of rewards for companies that do choose to obviously embark on that path. And I think as well, it's also kind of something that's come up in the news as well. There is a news update that I wanted to tag on to BCRs. This actually relates to EU BCRs, and it's an update made by the EDPB. And essentially, to explain the update that they've made, they've released a new sort of set of requirements for their processor BCR. But what they've actually done is kind of, in a very casual way, sort of made quite a significant departure from a previous understanding and position on what BCR processor BCRs could be used for, because previously the position has been, and it's been this way for a long time, that processor BCRs can also cover the sort of transfer that's made by the sort of third-party controller into the sort of processor bubble, the BCR processor bubble. So obviously that was very convenient for companies to have that sort of extra utility for the BCR. The EDPB have now essentially reversed that. And this was the subject of the Eduardo Oosteran webinar on last Friday. Is that they were talking about this. And it was just quite a strange thing that they've done there, because I mean, we see with things like the EU Digital Omnibus that there's this desire to kind of simplify things and to help businesses. Obviously, we see this in the UK with the doer as well. And this one just feels like, well, actually, you're kind of creating more compliance burden there.
Is that off the back of something in particular in terms of like a ruling or a court case, or just some new guidance that have kind of updated?
I don't think there's anything in particular that's actually prompted it. It's a good point. I think this is probably why it's created some kind of shockwaves, within the kind of small BCR space, people that use them and talk about them a lot. So, because for example, the UK, well, it'd be interesting to see how the IC actually responds to this. But our position, I believe, is that processor BCRs can continue to be used for that purpose as well, covering the third-party controller transfer. So I suppose it's another deviation of kind of UK and EU position. But yeah, I think it has come as a surprise. It's been referred to as like a backward step essentially. So yeah, I think it's one to keep an eye on because it goes against the global trend. In terms of we want to create more flexibility.
No, I mean that's really interesting. And I think you make such a great point in relation to sort of work that's currently being done to simplify data protection law for individuals. And it's an interesting point you make in terms of us deviating slightly from the EU. I think maybe you're right in that sense. Actually, I didn't really give it much thought. But I suppose we are kind of distinguishing, as we should really, considering the frameworks of our laws are very similar. But it doesn't mean that we have to continue to sort of act in that behalf. But it is a very interesting point in that we seem to be making different sort of shifts in that regard, especially with the stuff like the digital omnibus with the EU. So really, really interesting. And thank you so much for sharing your thoughts on the BCRs. That is definitely useful. And I know, as sort of Mark was saying, it's clearly going to be more beneficial for those bigger sort of multinational organizations, and could be something that is rightly said in the comments, a little bit daunting. I appreciate that.
I hope I didn't put anyone to sleep there. Anyway,
no, I think that was really valuable. But I think the value of getting them in place, is probably quite immeasurable. As you say, it's sort of like gold standard for everybody, isn't it? Which is lovely. But thank you so much for that, Mark. And everybody in the chat maybe
there's some funny comments.
Maybe right. I was really trying my best to bite my tongue. I didn't think it was that obvious. But maybe I just have a problem. I don't know. Or maybe it's the copious amounts of a Monster I drink that just keeps me on the edge. But no, thank you very much for that, Mark. Maybe we should spend a little bit more time being quiet. I think maybe I'll spend some more time on the podcast just being quiet. That's probably maybe we'll have a quiet section of the podcast where I'll just be quiet for a little bit. But that brings us to the end of the session. Thank you all very much for joining. Again, thank you, Mark, for joining us once more. Becoming a little bit of a familiar face, which I'm sure people are looking forward to seeing a little bit more of him because he brings some really great insight in the work he does. Next week, GDPR radio session as normal. No Kate or no Mark on Friday, which is devastating. But I'll be joined with Holly Miller, who is one of our lovely account managers. Spent a little bit of time with me on the spot desk as well. So that'll be a great session. Holly's just as chatty as me. So
yeah, I think it might be more of a light-hearted session than my BCR.
It was like a seminar.
Yeah.
But no, thank you very much, guys. We hope you have a lovely weekend and the rest of your Fridays, and we'll catch you next week.
Catch you next week, guys. Take care.